Hello and welcome. Thank you for joining us today. I'm Jacqueline Mensah. I'm a family lawyer at Bennett Griffin in Worthing, and I've been there since 2004, so quite some time now. I've got my colleague Sarah Pennicott with me. Hello, Sarah.
Good morning.
And between us, we've amassed quite a bit of knowledge and technical skill and insights in relation to family issues, and hopefully we can share those with you and enlighten. Hopefully we can entertain as well, so that would be a bonus.
That's right.
Hopefully, previously you caught our podcast, which was in relation to the all-important question of why should you use a lawyer? Why should you instruct somebody to help you with your legal issues? So hopefully that will have helped you understand why it's so important to get that advice, or at least to have the opportunity to have that advice. What we're going to look at today is a really interesting topic. We're trying to cover myths and, to some extent, legends surrounding legal issues. And this particular topic comes up so many times in the decades that I've been practicing. It's reared its head on a number of occasions, and it is the good old common law husband, common law wife. So those who are cohabiting, living together, and perceptions or misconceptions as to that which they would be entitled to should they separate, if the relationship breaks down, sadly, and what they're entitled to in law, perhaps opposed to or different to someone who's actually a spouse and is married. And I'm sure you've encountered the same, Sarah. It comes up time and time again.
Yes, yeah, it's definitely the most commonly held misconception, and something that people, just when you're talking generally to people, they just assume that once they've been together a certain period of time, or when they have children, that they are then in exactly the same position as if they were married. And it's quite frightening sometimes what they think their rights are compared to what they actually are.
Yes, it is. And it's also quite difficult for us as lawyers, because we like to give good news if we can, but we also have to be accurate and realistic and actually tell you what the law is. And I remember probably at least 10, 15 years ago, I had a lovely lady who was a client, and she was in her 70s, and she and her partner had lived together for 25 years plus. They were on their second relationship, so I think they'd both been married previously, and she'd pretty much done everything. She was cook, cleaner, bottle washer, gardener, the works. And so she had contributed to that relationship with everything she had, but perhaps not financially. And but she had contributed in kind, and they'd been together for so long, and she just presumed that they would share everything equally. That would be written in law for her. And we had to really sort of, break it to her gently or not so gently. And I remember we got a barrister on board as well, so that she fully understood that actually it wasn't as simple as if she was a spouse. She believed she had the same rights as a wife. So that was really difficult because it seemed so unfair. The law still distinguishes between spouses and cohabitees. And it's something that obviously, we as family lawyers have to look at. So we're trying to really do a bit of myth busting here. What we've got also is an acute increase in people living together and being cohabitees, as opposed to several decades ago and definitely centuries ago. There used to be very much a cultural stigma attached to living together, hence the whole notion of there being a sanctity of marriage, and therefore this created a disparity between the legal rights that somebody who was married had, as opposed to somebody who wasn't married, as if they were a second-class citizen in that respect. The Office of National Statistics has quite clearly found that the biggest increase in a family unit, a family type, is that of cohabitees. So it's, we all know it's on the up and up. And I think also we've noticed in our work that perhaps there's been quite a significant increase in the inquiries we've received about cohabitation over the last year or so, Sarah, hasn't there?
Yeah, definitely. I think before the pandemic, there was already an upward trend in terms of people cohabiting rather than marrying. But the Office of National Statistics estimate that in 2020, 127,000 marriages were postponed. So that's 255,000 people who don't have the rights that they would otherwise have had if they had celebrated the wedding. So whilst they're probably feeling a bit down about not having had their lovely big day, they could also have more serious implications in terms of what their rights are in relation to property and any other assets.
Yeah, absolutely. And of course, what we've got also for the first time ever, we've actually got a cohabiting couple at number 10 Downing Street.
Yes.
Boris Johnson and Carrie Symonds. So that's obviously made history in itself as well. So it's a subject which is really close to a lot of people and is affecting a lot of people in terms of how they feel secure in their day-to-day life. And, sadly, as to what would happen if they were no longer living together.
Yeah.
And you've got some of the history on it, Sarah, as well.
Yeah, so I've heard people sort of talk about this common law husband and wife. It was actually abolished in 1753. So how it's gone on for such a long time with people assuming that it still applies in current times is beyond me. I don't know where it's come from, but the fact is that they don't have the same rights. And I was reading an article that sort of said that it seems unfair in some ways, but the rules of property apply, not those rules that you would apply on a divorce, which look at the fairness of any division of assets. Whereas the law of property looks at your property rights only and takes any fairness out of the equation. So you might feel that you come off and it is a really unfair outcome. There's nothing you can do about it because it's completely different laws that apply.
Yeah. It's quite harsh, isn't it?
Yes. Yeah. And I think it's more, I mean, it is harsh for those people who don't know, but if people are aware of their rights and make their decisions with that knowledge, then that's up to them. They've got the information, but it's just because there is that misconception that actually, and people talk to friends and go, oh, you'll be okay because you've got children or you've been married, you've been together for this long. But it's that common misconception that feeds into the unfairness in a sense, and particularly where people have children.
Yes, it does. It does. I think that's very true. And that's why, obviously, as we said in our first podcast, you need to speak to somebody and you need to get that advice.
Yeah.
You also need to talk to one another. It's an obvious, and it applies again in every aspect of family law and beyond, that you need to have that conversation. So even if you have got this notion that everything will be split equally and the law will support you on that, whatever that may actually materialize as, you need to have that conversation at the very start and say, well, actually, this is what I've got, this is what I haven't got, what about you? And at least if you're on that same level, in family law, we always talk about full and frank disclosure in terms of finances and details. That's not necessarily something which applies to everybody in their day-to-day life and their personal affairs, but at least if you're on the same page and you know that you're exchanging the same level of information with the other person and you're both comfortable with that because you have that understanding, then that's the starting point, isn't it? And it's much easier to do that. Well, it may not be easier, but it's much easier to do it at the start when you're in a happy place than later on when there's a lot of anxiety and upset and obviously anger, sadly, in a lot of situations. So it is about that planning, isn't it, and having that conversation. And of course what you've got quite often is people are getting into the situation where they're living together, hopefully by choice, but as we've seen with the pandemic, for some people maybe it's been accelerated due to domestic or financial circumstances. But it's generally a happy, exciting time. But that's the moment at which you need to also stop and think, actually, should we put something down on paper, or at least have a document of some sort that records what we do want to happen on a day-to-day basis, and in the event that sadly it doesn't work out.
And also, I think having that conversation at the outset is a really good basis for building on that relationship and a healthy relationship between the two of you, because you know that you both have the same common intention. And if you don't, you may want to think about whether you want to carry on that relationship anyway.
Yes, quite.
But it's also thinking in terms of property ownership and so on. So how you own the property, whether you own it as what's called joint tenants or tenants in common, and whether you would want what you would want to happen to the property in the event of your death, because it's not just separation that's an issue where you're not married. There are also inheritance implications as well. So it's not just if you split up that it's a consideration. It's the whole bigger picture as well.
Yes, absolutely. It's any life change, isn't it? Any life-changing event. And the whole thing is knowing the general basis with regards to security, if you're a cohabitee, is get it formalised.
Yes.
Get it written down, get it formalised, get the advice first of all, but actually agree what you want and get it recorded somewhere, because you need layers of evidential documentation.
Yeah.
So in terms of as you say, in terms of property, the main thing is going to be the family home where you're living, the main assets as such. Get it recorded, have the tenancy severed so you own it as tenants in common, have that understanding as to who gets what in the event of something occurring. Make sure you update any wills, get a will, have an understanding about what your will actually mean, should sadly one of you pass on. And also in terms of the finances, we quite often look with people at cohabitation agreements, living together agreements, which is very much a blueprint as to how you want to operate. So as you say, Sarah, it's not just about what will happen if we do split up, but actually on a day-to-day basis, what's our understanding about responsibilities, about liabilities, about who's paying what, about gifts that we receive from anybody else, that sort of thing.
Yes.
And the beauty of a document like that is not only is it another layer of evidence to support your understanding and your agreement between one another, but also if you do then move on to become engaged, get married, you can use that document as a precedent, really, in terms of drafting other agreements. So you can have a premarital agreement, you could have a post-marital agreement, so you could continue it and revise it. So anything you've got, same with a will, of course, you can revise and update and make it a living document for you.
Yes. And I think that's another important thing that people need to be aware of, is that your circumstances will change over time. So maybe you enter into this kind of agreement at the outset of the relationship, or at the point you buy a house together, but that may need to be looked at again if you decide to have children, or if one of you has a huge increase in your income. You may decide that it's fair that they pay a greater portion into the property, but they may not get any additional interest. And it's just recording those things all the way through it and thinking about the times that you would want to review it. And not thinking because you've made it at the outset that it can't be reviewed. You can keep changing those, and it might be that what's fair at the outset isn't fair 10 years down the line, and you do want to change that.
Absolutely. And obviously the major change is having children for a lot of people, isn't it?
Yes.
So quite often, and then we have clients who ask us, well, what would happen if we had a child, or what happens because I've got children from a previous relationship? I mean, the baseline with children in any relationship and within a family is that their needs take priority. Their needs are paramount. So whether you're married or not, that's always going to be up there in terms of what needs to be looked at and accommodated. And obviously, other rights and entitlements may flow in terms of who's the primary carer, in terms of needs. It's, effectively, it's going to be about keeping a roof over the children's heads. So it follows from the children as opposed to, the mum or the dad in the cohabitee situations. And there is recourse and there is remedy in terms of securing the entitlement of the children through the Children's Act 1989. So there are ways and means. It becomes it's sort of a little bit more complicated and not so quite straightforward with cohabitees, because you are looking at various elements of the law which you need to apply to assist where you have parents who aren't married. So on the finances, as you mentioned, Sarah, when it comes to sorting out the home and who gets what, if sadly there are contested proceedings, then you're looking at old trust law. Now, it comes up, but generally speaking, probably from my experience, the benefit versus the costs incurred is disproportionate. So the more you've got set out and agreed in any documentation as evidence, the better, because those sorts of proceedings are not treated lightly by the courts. Many a time I've been in front of a judge on a Trust of Land Act application in relation to cohabitees and sorting out the home and who gets what. The judge just really effectively wants to look at who's paid for what.
Yes.
Essentially, the judge isn't so inclined to look at the history and the chronology. No. And the judge is most definitely going to say, from my experience, why are you here in terms of basically the money coming out of the family home. Everything you're paying for now at this point, you could have agreed previously.
Yes.
So generally speaking, unless you really have to make an application in relation to the law concerning cohabitees, you should try to avoid it, which is easy for anybody to say.
Yeah. And I think in terms of the Children Act application, again, it's quite complicated.
Yeah.
But it's not akin to the kind of agreement that you would have, or the kind of settlement that you would have during a marriage, because it can only look at the property, or you can look at lump sums and so on for the benefit of the child, but it is all related to the child as opposed to the adults.
Yeah.
And it, again, like you say, it's something to be avoided if at all possible. It's expensive and a complicated set of proceedings.
Yeah.
And only takes into account the lump sums and what the children need.
Yes, that's it. And of course, I'm going to say here in a completely biased way, as a collaborative lawyer, sit down and talk about it between the two of you, with a mediator, with a collaborative lawyer, and try to resolve it before you even think about any court proceedings, especially, in any event, but especially when you've got children, because you need to have a level of civil relationship, polite at least relationship with the other parent. That will continue for years, so it's better if you get talking now, even if you haven't been talking very much previously.
Yes, yeah. And I think we've talked a lot about the property and the family home, and quite often people assume because they pay towards the mortgage, moving on now for the children, but if they pay towards the mortgage or bills, that automatically they are entitled to an interest in that property, and it doesn't necessarily follow. And again, it is a case of deciding what you want at the outset as to how are you owning the property, how much interest does one person have as opposed to the other. So going back again to agreements and doing it at the outset.
Absolutely. It's all the preparation, isn't it?
Yes, and it can particularly become an issue when one person moves into a property that's already owned by the other. And it may be that to start with, it's almost a trial, and then they just settle into it and they've never really thought about those things. But at some stage, they should do. And then if they go on to buy another property together, but one person's bought more equity from previous property, and it's all of those kind of things that doesn't necessarily establish you a larger interest in the property because you've put in greater funds or you've paid the mortgage or the bills. It needs to be documented if possible.
It does. I think the key is it's nothing is automatic. I think a lot of people think, as you said quite rightly, people think, well, it's automatically I will get this, or automatically this will happen, or automatically I'll be protected. But it's not the case. It takes a little bit of legwork. And as you said, Sarah, I mean, in doing that work, you're also promoting your own relationship, so it's beneficial anyway.
Yes.
Even though it means having maybe some awkward conversations, but it is about future security, knowing where you're at, and a lot of it is about the preparatory stuff, isn't it?
Yes.
Which can be done, but so it is something which does quite often come to us as an issue for people, a real worry. And I think a lot of it is because initially it's surrounded by that euphoria of moving in, and it's all very exciting and it's all going to be great. And also maybe some people think actually it will be easier to sever and to move on because we're not married.
Yes.
And thinking of actually maybe the potential divorce proceedings as being the tricky, complicated bit that makes it messy, and therefore because we're not married it's all going to be easier.
Yes. Yeah.
But not necessarily when it comes to the finances.
No, exactly. And also debts, that's the other thing. We've talked a lot about assets, but quite often when people move in together they may borrow money in one person's name because it's simpler or because that person can get credit, but assume that they will both be jointly responsible for that. But that's not going to be the case, and you need to, again, if you're going to be jointly responsible for it, document it somewhere and deal with how that's going to be repaid.
Yes.
Because the liability for that debt will remain with the person whose name it's in, even if you have borrowed it for a joint benefit, or you might have borrowed it and given it to the other person. It doesn't matter because the liability stays with the person who borrowed the money.
Yeah, absolutely. Which is a real worry, isn't it?
Yeah. quite often something that comes up at the point of separation that they've assumed that something would happen.
Yeah, absolutely. And I think quite often also if you've got an obvious disparity where, as you say, somebody's previously secured their property, they acquired it from maybe in their own right or through a previous relationship or breakup, and they're in a relatively secure position. And then somebody moves in with them and they bring their debts with them, for good or for bad, but it's something that you need to actually speak about.
Yes.
And not just hope it will get better or resolve itself in some way.
No. And I think, as I say, we've talked mainly about property that people own, but what we haven't sort of touched upon yet is other differences. So if you were to divorce, then the court would look at your financial circumstances overall rather than any jointly owned property or any property you've lived in you think you have a beneficial interest in.
Yes.
So some people who have not married but assume that there's a common law spouse assume that on separation they may be entitled to some kind of pension share, or something from the other person's savings. And those are all things that over the course of a relationship, it may be fair that they have a pension share. If one person stayed home to look after the children, then their pension contributions are likely to be lower. And within the divorce process, that would be looked at. But it won't be if you're just cohabitees. And that is something that people aren't aware of.
No.
That needs to be addressed. And if you do a cohabitation agreement, although you couldn't have a pension sharing order, there might be some other way that you could compensate for that, perhaps a greater share of property or something akin to that, just to make overall fairness. And people are far more likely to come up with a fair agreement whilst the relationship is happy and there's no animosity between the two of you. And if things don't go wrong, it doesn't matter anyway, does it? It just moves the way in the event that things do break down.
Exactly. And most people would, definitely when they're in that happy place at the start and hopefully throughout, they would actually want the other person to be protected.
Yes.
They would want them to have that security in the event of something, awful happening. And also sometimes it's possible, looking at the particular pension and making particular specific inquiries, to actually appoint somebody or assign somebody to a policy, but it has to be looked at in particular. Because the general rule is that, if you're not married, you're not next of kin. That's the key thing, isn't it?
Yeah.
And with that, being next of kin confers those automatic entitlements and rights. And that's what we're talking about here, is that there's no automatic next of kin. And it's being aware of that in other areas. So, I mean, obviously that sort of, that has a ripple effect in terms of lots of areas of life, that you're going to have to specifically refer to this person as the person you want to be notified or want to have the benefit of something.
Yes, yeah, exactly. And again, it's just the conversation, isn't it? And it's sometimes that it doesn't even cross people's minds that you might be prejudiced in the event of their death because you're not married and so on. So it's all about open communication.
Yes, it is. Which is what we're all about, Sarah, isn't it?
Yeah.
To encourage that.
But I think the message is that it's not too late in the relationship to come up with an agreement and to formalise any understanding you already have, but also just to know what your rights are. As we said last time, you don't have to follow it. You might decide, okay, I'm happy cohabiting and I don't want an agreement, but equally you may want to do something to protect it, to protect your interest and what you think your interest is.
Yes, that's it. It's the whole thing of you don't know what you don't know. As long as you've done your best, you've used your efforts to find out what you really probably should know, and you've had the opportunity to do so. If then you decide to retreat or you think it's not for us, that's not the way we want to deal with it, that's fine. It's a very personal thing, but it's just being aware of that, isn't it?
Yes.
And I think that's basically what we're all about with these podcasts, isn't it? We're just saying to you that this is how it is. This is what the law says. You need to appreciate that. We're here to help you with that. But also there's a little bit of tailoring for you as well. And as long as you know it's out there for you, it's then up to you as to how it works for you and your family.
Yes.
So, it's not all prescriptive.
No, absolutely. No, it's just know your rights, I think. And
that's it. So I think we've probably covered most of the aspects of cohabitation there.
I think we have, yeah. Hopefully we've driven home the message that it's not the same as marriage.
No, exactly. And I can't believe that it's been around since the 1700s.
I know.
And it's still there. It's myth. But it's all about knowledge, isn't it? Knowledge is power. So we've got a few more podcasts up our sleeve.
We have.
We're looking forward to them. So this is part of a series of myth busting in terms of legal issues. The next one, hopefully you'll join us for the next one, is going to be about behaviour. So behaviour in relation to various angles in terms of divorce proceedings, separation, finances, how does it impact generally? So sort of various aspects of that and how a lot of the time people have perceptions of what that will mean within a family issue and within family law. So hopefully you'll join us for that. We're looking forward to that one. And that's going to be probably in about a month's time or so.
Yes.
Sarah?
Yes, that's the plan. So we've got the previous podcast as to why you should instruct a solicitor. We took a break then to do a joint podcast with Carpenter Box about pinch points, where you should look at your situation and review, protect your future financially. And then we're aiming to do it every month thereafter.
Brilliant.
Excellent. So we should hopefully see you all then.
Lovely. See you then. Take care and have a great day.
Thank you. Bye-bye.
Bye.